Hello, hello, everybody. Welcome back. Thank you so much for being here. I guess I probably should put on my glasses if I want to be able to see the documents that we're going to be going over today. Guys, we are circling back around to the case of the murder of 13-year-old Abigail Williams and her friend 14-year-old Liberty German, who were murdered on February 13th, 2017, in Delphi, Indiana. Of course, this is a notorious case. I think most of us know about this case. We probably don't need to get into the details, but basically, this man, a guy named Richard Allen, is on trial. Well, not on trial yet. He is facing trial for the murder of the teenage girls in Delphi, Indiana. Now, what we're going to be talking about today, because my channel is all about true crime documents, deep dives, and drollery. Today, we're looking at documents, and we might get into a little drollery as well. The conversation is going to be surrounding kind of a continuing battle between these two guys, Misters Baldwin and Rozzi, the defense counsel, and Her Honor, uh, Special Judge Fran Gohl. Now, I want to do a little straw poll here, just a quick straw poll, and it'll take a minute for them all to come in. I know, what do we have? We only have about 30 people on right now, but listen, I want you to put in the comments, yes, if you think that Judge Gohl is being fair to the defense in this case, and no, if you do not. And I'm just going to do a little straw poll. We're going to go through it and see how we're feeling as an audience about Judge Gohl. Now I'm going to circle back around to that, okay? I have seen it in the comments already that, yeah, I do have a case page on my website. Let me bring that up for you guys. If you go over to ye old website, gavinfish.com, click on cases, and scroll down because they are in chronological order. Get down to about 2017, and you will find Abby and Libby here. So you can go to the website and you can see a lot of my coverage and some of the documents in the case and so forth. Okay, so that is a question that we've already had. Okay, so remember the question is Judge Gohl fair to the defense, to Richard Allen and his lawyers? Yes or no? And then we're going to count these up, okay? We're going to count these up. Let me see if Jamie's here. Is Jamie here? Jamie is here. Let's see if Autumn's here real quick. Autumn is here too. Okay. Jamie and Autumn, can you do me a favor and just keep an eye on those? Maybe keep a tally, and then we're going to see what the poll results are, okay? All right. What we're going to do here first, guys, we're going to go over to this document right here. Boom. Okay. This is a document that was filed on May 17th by the defense. Let me get up here to the top. So this is the defense second verified motion to disqualify judge and request for findings of fact and conclusions of law upon denial of this request if the court denies the request. So that is a very long title. But basically, they're saying, hey, we want judge to be disqualified. And there are several things that they mention in here that I'm going to come back to. But let's go over to Judge Gohl's order and let's take a look at this. This came out on the 31st, if I am not mistaken. Okay, again, this is Judge Gohl, Judge Fran Gohl, and she is writing this, right? Okay, the court has reviewed the defense second verified motion to disqualify judge and request for findings of fact and conclusions of law upon denial of this request if this court denies this request. Filed May 17th. World's worst title, but the lawyers are not known for their brevity, right? Okay, as trial rule 52 is not applicable in criminal cases, the defense's request for findings of fact and conclusions of law is denied. So they're like, okay, listen, Judge Goal, I wish I had like a little puppet thing here. She's going, hey, no, you're asking for findings of fact, conclusions of law. That does not apply in criminal cases. So, no, we won't be doing that. However, she continues, the court will address each of the defendant's allegations in this order. This is not a super long order, just a few pages, and I'm not going to go back to all of this stuff in this document because this is a 40-page document, but we'll get back to a couple things, okay? The defendant claims the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel on June 14th, 2023 regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. Let's real quick just go over to page, I think it's page 9 of this document. Okay, so paragraph 23, in preparation for the hearing, defense served, this is Baldwin and Rozzi speaking again. The defense served a valid subpoena on witness and Westville inmate Robert Bastone to appear for the June 15th, 2023 hearing. When a deputy from the Carroll County Sheriff's Office went to the Westville Correctional Facility on June 14th to transport the inmate to the hearing, the inmate became uncooperative. Carroll County Chief Deputy Toby Lazenby contacted Judge Goal about the situation, and Judge Goal told Deputy Lazenby to leave the inmate there if he did not want to come to the hearing. Lazenby was the first witness called by the prosecution at the June 15th hearing and certainly will be called as a witness at trial, yet Judge Goal and or her staff communicated with this prosecution witness the day before his testimony without the full disclosure of said communications to the defense. All right, getting back to what Judge Goal says. The court requested a report of the witness's refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court, is what Goal tells them. Okay, defendant claims the court engaged in ex parte communication with the Carroll County Sheriff regarding defendant's housing, transportation, and safety during jury selection and trial May 13th through 31st, 2024. Let's go to that. I think it is page 12-ish. Yeah. Okay. On May 3rd, 2024, the defense alleges. The defense deposed Sheriff Tony Leger, or Liggett, I don't even know how to pronounce that, for which I apologize. During this deposition, it was learned that the court has engaged in activities with law enforcement and prison representatives regarding Richard Allen's housing, both during scheduled jury selection in Fort Wayne and during the scheduled jury trial in Carroll County, Indiana. The court failed to communicate any of these plans to the defense in advance of the court's actions. Again, the court appears to have engaged in ex parte communications with the state of Indiana. Okay, getting back to Judge Goal's comments. These communications, she says, were administrative in nature and did not address any substantive issues. The communications were directed to where the defendant would be housed during the trial and who would be conducting transportation. The court did notify counsel where defendant would be housed during the trial, as he is still under the safekeeping order, in an email, but did not inform counsel of the communication as nothing substantively was discussed. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel the hearing upon the filing of this pending second verified motion to disqualify. For me, I think that this is probably something that is going to be valuable at appeal in the event that Mr. Allen is convicted. Hey, Jamie and Autumn, will you guys tally? You know what? I can do this, no problem. So I'm gonna type in yes. What do we got? 1, 2, 3 for yes. Oh, Autumn has it all. Okay, 3 for yes, 8 no, 1 unsure. Okay, let's just make sure that that's still the same yes. We have 3 yeses. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 no's now. Okay. So the question being is Judge Gold being fair to the defense? Yes or no? We have 3 people saying yes, 11 people saying no, which I find interesting. I don't know. I haven't found a time where I have felt like Judge Gold is completely. You guys are going to crucify me for this, but I think she's been a pretty good judge in all this. And this is probably a good moment to say, hey, if you want to get my attention, if you want to react to that comment by me, if you want to get to my attention, in the live chat, just put my initials in there and I will be able to see your comment. I think she's been a good judge. However, having said that, I do think that this point is probably going to be good on appeal in the event that Mr. Allen is convicted. Okay. Counsel claim the court invited the state to limit defendant's Sixth Amendment right to present a defense. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28, 2024. Let's just see what she's talking about here. I think, here we go. All right. Both Judge Gold and the prosecution have known since the filing of the first Franks notice on September 18, 2023, that the defense will be relying on a third-party suspect defense. Guys, just so you know, there are... in the American court system, which is based on English common law, there are just a certain number of valid defenses for each kind of crime. In this case, we're talking about murder, right? So there are only so many valid defenses, and the laws are extremely, well, I wouldn't say they're extremely clear. I would say that they are extremely founded in long legal precedent. So the defense can say it wasn't our client, it was somebody else. And that is a valid defense, but they have parameters within which they need to work. Okay? And that is, I think, what Judge Gold has said. But let's see what the complaint is. In rebuttal to the defense's theory regarding third-party perpetrators, the prosecution listed an Odinism expert on their supplemental witness list emailed to the defense on March 17th. At no time between September 18th and April 27th did the prosecution take any action to prevent the defense from pursuing a third-party perpetrator defense. During this time, the defense conducted many depositions related to their third-party perpetrator defense, and in addition made numerous requests to the state seeking additional discovery regarding third-party suspects. On April 28th, Judge Gold directed an email to both the prosecution and defense regarding scheduling matters, and without any prompting informed the defense that she, Judge Gold, was fully aware of the law regarding third-party perpetrator defenses and would be prohibiting the admission of such evidence by the defense unless some nexus between the two could be proven. This unprompted comment was akin to an invitation by Judge Gold to the prosecution to file a motion in limine that would prevent the defense from presenting evidence that third-party suspects committed the murders. And, well, I'll do this last one too. Approximately 12 hours later at midnight on a Sunday night, the prosecution filed its motion in limine requesting that Judge Gold not allow the defense to discuss third-party suspects. The court's invitation to the prosecution to seek such limitations creates a rational inference of bias in favor of the state of Indiana and against the defense. That's the complaint. Okay. Okay. So Judge Gold continues. Counsel claimed the court has disparaged them and ruled on defense pleadings. Oh, wait a minute. No. Counsel claimed the court invited the state to limit defendant's Sixth Amendment right to present a defense. Court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28th. She's saying, yeah, I did exactly that because there are parameters inside which you need to operate. So, I mean, is it possible that invited the prosecution to file that motion? Yeah, but I think the prosecution probably would have filed that motion anyway. Now, hey, let's see what you guys are saying. Please don't hate me. Please just be respectful about it. But Susie Hat 44 says, hold on, let me bring up Judge Gull because we're talking about Judge Gull. Gavin, have you not been paying attention? She is the worst. KT Recovers says, Gavin, the judge refused to allow the attorneys to represent Richard Allen protocol after they were removed and before the Indiana Supreme Court reversed Gull's decision to remove them. She has biases. Hey, I will not argue whether or not she has biases. Everybody is biased. What the judge is supposed to do is favor the law. The judge is not supposed to favor the prosecution or favor the defense. And guys, typically speaking, in my experience anyway, all of these people work together in normal circumstances. Now, I know that this is like a special circumstance, right? Got a judge that is appointed, and we've got a lot of stuff happening. But it is, I guess what I'm getting at is it's very common for judges, for prosecutors, for defense attorneys, for bailiffs and sheriffs, and they all interact with one another. They are all co-workers with one another. It's not uncommon for them to be friendly with everybody involved. And it's not uncommon also for them to not like certain people, for sure. That is for sure. But her bias is supposed to be toward the law. Now, in this last one, I think that she is making a valid argument. Hey, listen, I require counsel in all cases that I sit in judgment over to follow the law. And so I think she's probably in the clear here. I think that previous one probably not, but I think she's probably okay. And as far as the Indiana Supreme Court reversing decisions, that's the point of the appellate process. Lower judges get things wrong all the time. And that is the point of everything. Oh, let's see. KT says pro bono. So let's see. The judge refused to allow the attorneys to represent RA pro bono after they were removed and before the Indiana Supreme Court reversed her decision to remove them. She is biased. Yeah, okay. So, but my argument still stands. I mean, if she is biased toward the law, is there something in the law that wouldn't allow that? I'm not sure. Either way, I think she's been okay. KT, Gavin, she cannot have biases and sit as a judge on this case. She cannot refuse a client the attorney of his or her choice. She's wasted taxpayer money. That is actually incorrect. That is actually incorrect. Respectfully, KT Recovers. In circumstances of indigence, the Sixth Amendment of the Constitution guarantees adequate counsel, but it does not guarantee counsel of choice, and that there are long precedents on that. She can refuse the client the attorney of his or her choice, and the Indiana Supreme Court reversed on something completely unrelated to that part of it. But thank you for the comment, and I appreciate the pushback. Thanks. Okay, let's get back to the document, and I'm not going to go back and forth anymore. That was just for the first three, I guess. Counsel claimed the court has disparaged them and ruled on defense pleadings without hearings. The court's comments about counsel's performance were documented in the court's order of April 30th regarding their handling of discovery materials. If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. Allegations the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence. Well, that's interesting. Any admissible evidence? There might be evidence that she has treated the prosecution more fairly, but not admissible evidence. I think that's interesting. Provided by the defense at the March 18th, 2024 hearing, the court was notified on May 20th of an inquiry by the Indiana State Police to the court reporter via email on May 9th regarding ex parte communication received by the court from Gary Baudet, which was previously provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation. The defendant blames the court for ex parte pleadings which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state but not the public. Counsel's staff contacted the court staff and were advised that the statewide Odyssey case management system, not DocsPop as alleged in the pleading, has a distinct process for filing ex parte as opposed to confidential. The court did email defense counsel a tutorial paper, authored by JTAC explaining the process. Since that communication, defense counsel have had no issues with their staff properly filing ex parte pleadings. Wow. Accusations of violating rules on access to court records have been completely explained and dealt with, including by the Indiana Supreme Court in the first writ of mandamus filed by defendant. Counsel claim their motions are treated differently than those motions filed by the state. The court has set hearings on pending motions, which have now been continued due to the filing of this motion to disqualify. When defendant files pleadings, the state is entitled to file a response. The court follows Trial Rule 6 regarding time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's responses. Once the issues are closed, if a hearing is required, one will be set. I think that's pretty straightforward. Defendant asserts that the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6th, defendant filed a motion for speedy trial. The court granted that motion on March 7th and set the case for speedy trial May 13th through the 31st. On April 30th, defendant filed a motion for a pretrial hearing, which the court set for hearing on May 7th. At no time prior to the May 7th hearing did the defendant advise the court that 3 weeks for trial was inadequate. At no time prior to May 7th did defendant indicate a belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, or more importantly, without notice to the potential jurors. While the court agrees a continuance of the trial is harmful to the defendant and the state, it could have been avoided had counsel communicated prior to May 7th. Counsel represent they notified the court on or about October 4th that they would need 2 weeks to present a defense, but the court has no record of that communication, nor any recall of such communication. Counsel's assertion that between all defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer is irrational and unreasonable. I find that to be true. The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. The court is not required to guarantee equal time for both the defendant and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their case however long it takes. Had counsel notified the court within days of receiving the March 7th court order setting the case for speedy trial from the 13th to the 31st, that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th to June 14th. Trial is now set for October 14th to November 15th, as requested by the defendant. This is well written. Counsel accused the court of engaging, excuse me, just for a second, guys. And let's see what so KT has a correction for me. She cannot refuse Alan the attorney of his choice if they are offering services pro bono. You might be right on that. I stand corrected. I apologize. All right. Counsel accused the court of engaging in extrajudicial activity. Counsel is correct that on July 9th, 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about their team winning the tournament. If counsel's allegations in this part of their motion are well-founded regarding a potential witness's alleged social media activities and are presented to the court for ruling, the court will rule accordingly. Concerns about anticipatory rulings are not reasonable. It's good. Defendant asserts the court has denied reasonable requests for funding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to for $26,000 for investigative services from June 4th through October 16th of 2023 was in fact returned to counsel as no documentation was provided for services. No documentation was submitted until quite recently. Without proper support and documentation, the court authorized that invoice for payment on May 17th. Defendant complains that public confidence in this case has eroded. As counsel should know, criminal cases are tried in a court of law, not in a court of public opinion. An independent judiciary requires that judges decide cases according to the law and facts without regard to public clamor or fear of criticism. The court continues to receive ex parte communications from the public criticizing the court, both personally and professionally, and threatening the court with bodily harm and injury. Guys, this is never okay. Okay? If you guys, I know none of you are doing it, but if anybody watching this sometime in the future thinks that that is okay to send a letter to a judge threatening bodily harm and injury, it's not okay. I don't care how much you disagree with a person. Don't do that. You can send communications about your opinion for sure. That is your right, but never, ever, ever threaten. Don't threaten anybody. Don't do that. The court continues to provide these communications to the parties. The court is not interested in memes and other social media content that can be easily located on the internet. This is paragraph 129. Hold on, let's go to paragraph 129. Let's see this. All right. Paragraph 129. Evidence of the erosion of the public's confidence in Judge Gull can be shown through letters that Judge Gull has received, as well as letters the Indiana Supreme Court has received, as well as memes and other social media content that can easily be located on the internet. So she's basically saying, who cares if public confidence has eroded in me? That is awesome. I actually love that very much. The court cannot be swayed by inappropriate and ridiculous outside influences. Defendant further claims the court has refused to order the state to comply with discovery rules. The court has set defendant's motion to compel and motion for sanctions for hearing, which has been continued due to the filing of this motion to disqualify. The previous defense motion to compel was denied without hearing as it was unsupported by evidence. Defense counsel alleged bias by the court, only allowing cameras in the courtroom on one occasion. The court has not allowed cameras in the Carroll Circuit Court due to its limited size and layout. The court did allow cameras in the Allen Superior Court at the hearing conducted on October 19th. The hearing was not conducted, and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in the ability of the media to cover hearings appropriately. The judge does have that power. Jennifer Dobbins put GF. Hello, GF, and all the fishies. Hello, Jennifer. Thank you for being here. The court has issued adverse rulings against the defendant as well as against the state of Indiana. Adverse rulings do not support a reasonable basis for questioning the court's impartiality, nor are they grounds for disqualification. They are just adverse rulings. Defendant's second motion to disqualify judge and request for findings of fact and conclusions of law upon denial of this request, if the court denies this request, is denied. Signed, Francis C. Gall, special judge. All right, guys. Let's see what you have to say. Let's go down here. Sandy says Judge Gull is the worst judge I've ever seen. She's clearly working to help the prosecutor. That is the opinion of many people. Let's see. Lynn GMB says this is the third time they motioned to remove the judge, and Superior Court said she is not to be removed. Let's see. This is funny. This is two comments right in a row. You're right, Gavin, and you're crazy. Okay, need some Z's. I'm going to take that as a happy jab, a nice little happy jab. Let's keep things respectful with one another, though, okay? Let's see where... Oh, I'll check in on the vote here in a second. Dowlands, how do I say that name? I don't know. People are taking anything the defense says as truth. Yeah. Amy says I am out of my mind. Again, I will take that as just a friendly jab. Let's keep it nice and respectful. Let's see. Lynn says the judge is too smart for the defense. What else have we got here? I'm gonna skip down here a little bit. KT Recover says, prediction. Richard Allen is guilty, but there will be a mistrial due to Gull's inept malarkey in this case and the ISP's crappy investigation. This case could have been solved at within 2 weeks of the crime. Mistrial due to inept malarkey. I mean, do you think that is a form that the jury will come back? They're like, I'm sorry, we can't come to a decision on this one due to Judge Gull's inept malarkey. Did Judge Gull engage in inept malarkey? Check this box. No, I get what you're saying. I'm just, I don't know. Okay, final poll tally was, if Judge Gull has been fair, 6-14. So what is that? 6 out of 20 is 30% of you say yes, 70% of you say no. Thank you, Jamie. Let's see. Oh, Autumn, you can become a fanatic too. Autumn is one of our amazing moderators. Autumn is also one of the admins of the Fish Tank, which you guys should go check out. If you go over to my website, Aruni, and click on this little fish up here in the corner, that will take you to the Fish Tank on Facebook. So if you're on Facebook and you like to talk about true crime and all sorts of cases, old and new, please just either click on that fish or search the Fish Tank on Facebook and you will find us there. Thank you, Autumn, for that. Let's see. This is a jury trial, says Lisa Grace. Therefore, the judge won't decide. The jury will. Yeah, the judge's job is to rule on matters of law, not on matters of fact. The the only the only judges of fact in any trial are the members of the jury. So hopefully, now I will say that in like that second thing in the second paragraph in Judge Gull's order, I think that I think the whole, this whole thing about the defendant, let's see, I can't remember which one. Yeah, there was something in here. Now I can't even remember which one it was. Maybe it was this one, the ex parte communications with sheriff, or with with the sheriff. That might be a pretty good reason for an appeal for sure. Let's see. Tiff Knox, you came in on a spicy one. It's spicy. That's funny. All right, you guys. Yeah, we haven't seen the evidence. It is for a court trial, not the public. This is one that I would love to go and just be in court for. And I think, unlike other YouTubers, I think that I could go to a hearing and go to a trial and not come to like fisticuffs. I think I can do that. I mean, it's not guaranteed, but I think so. I mean, I've lived most of my life without having to do that. So yeah, let's see. Blue Bonnet brings up Karen Reed's trial. Like Karen Reed's trial, too many coincidences toward other possible suspects, in my opinion. I don't think Alan did it. He's just the fall guy. This murder was ritualistic, in my opinion, and that's what the defense thinks as well. Autumn, holy cow, I am pretty close to 74,000. What am I at? Last I looked, it was like 73.8. Guys, if you have not subscribed yet and you like this kind of content, please consider subscribing. I would really appreciate it. Yeah, we're at 73,898. That's pretty fun. Pretty fun indeed. Let's see. The judge gets to decide evidence that gets to come in. Tiff, that is true. And if she allows evidence or disallows evidence and she is not in harmony with the law, that will be a very good reason for an appeal. And I know that sucks, right? If he is an innocent man, and I don't know that he is, but if he is an innocent man, I mean, we're supposed to assume that he is until he's been proven to be guilty. Yeah, we don't want innocent people convicted of crimes. 100% for sure. But we also, I mean, so if he were innocent and he were convicted, the appellate process is there for him. And I know that sucks, but that's just kind of the way it is. Let's close out by remembering that we are talking about two little young teenage girls, 14-year-old Libby German, 13-year-old Abby Williams, who were murdered that fateful day in February of 2017. And not forget that we do have victims in this. It's very easy, I think, for a lot of us in the true crime community, myself included, to forget that we're talking about real people's lives here. So thank you all for keeping it respectful. Thank you for joining me tonight. Autumn, thank you once again for that amazing super chat. Make sure you hit like for Gavin. You're always repping me. She's absolutely amazing, taking care of me. Thank you for doing that. Guys, I appreciate you joining me tonight. Like we said, the channel is growing. If you would like to support me, and there are so many ways to support me in my work that I do here on YouTube. The easiest one, and the one that is free, is to like and subscribe. And for doing that, I deeply, deeply appreciate it. Thank you for doing that. We just got one more, 73,899 we're at now. All right, guys, I'll see you on the next one. Have a good night. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.